I think we have Eamon Javers from Washington who's been going through this opinion and this decision. Eamon, what can you tell us?
Yeah, Sarah, first of all, we can say that the vote here is 5-4. So that's a break from the Supreme Court's recent run of 6-3 decisions. So that's an interesting one. We'll have to look at the makeup of that 5-4 decision. And one of the things that I'm looking at in this decision on page 17 of the ruling is this issue of whether or not the Supreme Court was going to decide whether this was for cause or whether this was going to be about Lisa Cook and whether she was allowed enough formal notice and process in this effort by President Trump to fire her from the Federal Reserve Board. And what the Supreme Court has said here is no matter the precise definition of cause or the scope of our review of any such determination, the president failed to afford Cook the procedural protections to which she was entitled by statute. Without such protections, she could not properly dispute the charges the president laid against her. We thus need not address Cook's constitutional due process agreement, for the statute alone makes it unlikely that the government will prevail on appeal as to the validity of the procedures used to fire Cook. So one of the things they're focusing on very intently here is the question of whether or not there was a proper procedure here around firing Cook. Remember, what the president was arguing here was that Lisa Cook was not entitled to any kind of formal notice in this process. The mortgage fraud allegations that the president and his allies made against her were good enough for the president to have the authority to fire her. And the district court, the president argued, did not have the authority to reinstate Cook. And what the Supreme Court here is saying is that ultimately the president failed to afford Cook the procedural protections to which she was entitled by statute. So that's a key point, guys. And we're just going through this decision now. 83 pages, so a lot to digest. A lot of it's in Latin. So we're working through it to understand the full implications here. But obviously, this is a significant rebuke for the president of his position that presidents are entitled to fire members of the Federal Reserve Board effectively for any reason they want. Although in this case, the president said it was around this cluster of mortgage fraud allegations against Lisa Cook. So I think this is a substantial victory for those who wanted to see Federal Reserve independence stood up, and a blow for those who wanted to see the president's executive authority empowered dramatically. Guys, back over to you.
Yeah, Eamon. Meantime, we might give you a minute to work your way through Trump v. Slaughter and the president's ability to fire heads of independent agencies. While you're doing that, though, let's turn to Steve Leisman and get some thoughts regarding the Cook case. Morning, Steve.
Good morning, Carl. Yeah, I am interested in the Slaughter case because what seems clear about this decision from Chief Justice Roberts is he's signaling out the Fed as being different from other institutions out there. He points out in the decision that the Fed has its own budget that's separate from Congress, that even private bankers have a say in the Federal Reserve. And there's one line here that stood out to me in the decision. Not only the fact of independence, but also the appearance of independence is key to the Federal Reserve's design. And Chief Justice Roberts has a history of the development of banks, pointing out that the National Bank actually predated the Constitution, pointing out the court decides this application on the narrow ground that the president failed to afford Cook the procedural protections. But I think the question may be on the table here, guys, as to whether or not this decision actually strengthens the independence of the Federal Reserve, perhaps putting other presidents on notice, and this one as well, that you cannot just fire a Federal Reserve governor. I'm not sure what the new standard would be, but the standard that President Trump used is not on with this Supreme Court.
Just looking at some of the dissents, Justice Thomas dissenting, saying that Cook's office was not properly protected by due process. Apparent mortgage fraud was a valid cause for removal, that the Federal Reserve Act does not require notice or hearing before removal, and that any restriction on the president's removal power over executive officers violates Article 2. Just interesting to see the different arguments here because this was such a split decision of 5-4.
That is addressed a bit in Chief Justice Roberts' decision. In the sense that he says without due process, there basically is no independence. So I thought that was interesting. Roberts did address something of the dissent in there and saying there was a line in here. The court rejects the government's half-hearted contention that Cook, in fact, received due process. At minimum, Cook was entitled to some explanation of the evidence at issue, some avenue for a response, and a deadline by which a response would be due. And all of that, the court is contending, or the majority is contending, is central to the Fed having some independence rather than the ability of the executive to fire a governor at will.